Question 1. When considering California's wage statement requirements, which of the following best illustrates violation that could lead to statutory penalties even in the absence of actual harm? A. Failure to include the employee's full address on the wage statement. B. Listing the pay period as biweekly without specifying dates. C. Using abbreviations for the employer's name without full legal reference. D. Providing net pay figure without itemizing tax deductions. Answer. Correct answer. B. Listing the pay period as biweekly without specifying dates. Explanation. Under California Labor Code SS 226A, employers must furnish accurate, itemized wage statements including specific beginning and end dates of the pay period. Courts have ruled that failing to include these dates can constitute knowing an intentional violation, regardless of whether the employee suffers actual injury. See Lopez v. Bryant and Associate LLC 2017. Unlike federal standards, California imposes strict liability where even technical violations may trigger statutory penalties. Abbreviations, option C, and formatting preferences are not per violations. The address of the employee is not required. A and net pay may be listed as long as tax deductions are itemized elsewhere. D. Question 2. Given the circumstances, what is the most appropriate initial step for an HR professional when an employee named Fatima discloses a newly diagnosed disability that may require adjustment to her work schedule? A. Immediately request a physician's letter verifying the disability. B. Begin the interactive process to explore reasonable accommodations. C. Suggest that the employee begin a medical leave of absence. D. Refer the employee to the company's EAP for emotional support. Answer. Correct answer. B. Begin the interactive process to explore reasonable accommodations. Explanation. California law under PHRca Code SSN mandates that employers engage in timely, good faith interactive process once they are aware of the need for accommodation due to disability. This process is not dependent on written medical documentation as precondition. Option A is premature unless the disability is unclear or contested. Medical leave. C is not the default accommodation. D may support but does not fulfill the legal obligation. Employers failing to initiate the interactive process may face liability regardless of whether final accommodation is made. Question 3. From a practical standpoint, which of the following scenarios would most likely trigger Cal Warn Act obligations for a California-based company with 95 full-time employees? A. Laying off 20 employees over a period of 60 days. B. Closing a single department affecting 45 employees with no transfer options. C. Terminating 10 remote workers scattered across the state. D. Reducing hours by 45% for 40 employees for 25 days. Answer. Correct answer. B. Closing a single department affecting 45 employees with no transfer options. Explanation. The California Warn Act, Labor Code SS 400-1408 applies to employers with 75 or more employees and requires 60 days notice for mass layoff equals 50 employees, plant closure or relocation. However, courts have interpreted closure broadly. If 45 employees are impacted with no reassignment options and the entire department is shut down, it likely qualifies as plant closure under California's more expansive definition, unlike the federal one. Option A is below the 50-employee threshold. Option C doesn't meet the numerical or geographical test. Option D fails because temporary reductions under 6 months don't trigger Cal Warn. Question 4. To illustrate this point, consider that Eastern UN, an HR director, receives a complaint that a manager allegedly made racial comments toward a subordinate. The subordinate is hesitant to cooperate. What should Eastern UN do first to ensure compliance with California's PHRca requirements? A. Respect the employee's wishes and take no further action. B. Conduct limited investigation focusing only on the complainant's testimony. C. Initiate prompt and thorough investigation regardless of the employee's cooperation. D. Wait until another employee reports similar behavior. Answer. Correct answer. C. Initiate a prompt and thorough investigation regardless of the employee's cooperation. Explanation. California's Fair Employment and Housing Act, Gov. Code HRCI imposes an affirmative duty on employers to take reasonable steps to prevent and promptly correct harassment and discrimination, regardless of whether the complaining party cooperates. Option A is non-compliant. Option B is inadequate as it may miss other witnesses. Option D delays intervention in violation of the employer's proactive duty. The DFA guidance stresses that investigations should proceed independently of complainant cooperation when necessary to prevent workplace harassment. Question 5. In light of recent developments, what are an employer's obligations under California law when an employee named Rachel, who is pregnant, requests intermittent leave for prenatal care visits? A. Deny intermittent leave, unless it exceeds 4 consecutive hours. B. Grant intermittent leave under PDL without penalizing the employee. C. Require the employee to use accrued vacation first. D. Provide leave only after the employee's HRCI is exhausted. Answer. Correct answer. B. Grant intermittent leave under PDL without penalizing the employee. Explanation. Under California Government Code SS, employers must provide up to 4 months of pregnancy disability leave PDL per pregnancy, and this leave may be taken intermittently or on reduced schedule for medically necessary reasons, such as prenatal visits. It operates independently of PHRCA and does not require substitution of leave unless the employee chooses. Option A violates the regulation's flexible leave usage. Option C contradicts PDL provisions. Option D falsely link PDL eligibility to HRCI exhaustion, which is incorrect. Question 6. What factors contribute to determining whether time spent traveling to a training site in another city qualifies as compensable under California law? A. Whether the training is mandatory and occurs during regular working hours. B. Whether the employee is offered meals and lodging. C. Whether the employee uses personal or company transportation. D. Whether the employee consents to the trip. Answer. Correct answer. A. Whether the training is mandatory and occurs during regular working hours. Explanation. According to California LSE opinion letters and Labor Code SS, travel time is compensable when it occurs during the employee's regular work hours or if the training is mandatory. Option A captures the primary legal test, whether the employer provides lodging or the employee consents. B. D is irrelevant. Personal or company vehicle use. C. Only affects expense reimbursement, not compensability. Employers must pay for all time that qualifies as hours worked per Industrial Welfare Commission wage orders. Question 7. Demonstrated by a recent audit, a medium-sized company in Riverside had no documented injury and illness prevention program in place. Sophia, the HR manager, argued that informal safety talks were enough. What is the legal flaw in her argument under OSHA rules? A. Informal programs satisfy federal OSHA, so state rules are redundant. B. Verbal training is allowed under OSHA for companies under 50 employees. C. OSHA requires a written IP regardless of company size. D. A documented plan is only required after an accident occurs. Answer. Correct answer. C. OSHA requires a written IP regardless of company size. Explanation. Under California Code of Regulations, Title 8 SS, all California employers must establish, implement, and maintain written injury and illness prevention program. This includes hazard identification, employee communication, safety training, and record keeping. Verbal safety talks. B. Are not substitute. There is no small business exemption. C. Informal programs are insufficient under OSHA, which has more stringent requirements than federal OSHA. Post-incident creation of plan. D. Fails to meet the proactive requirement. Question 8. The core principles of legal posting requirements dictate that which of the following practices would place an employer at risk for non-compliance. A. Displaying all required state and federal posters in English only. B. Posting required notices electronically on the company intranet. C. Including wage order posters in the employee handbook. D. Posting the notices in a location visited weekly by employees. Answer. Correct answer. A. Displaying all required state and federal posters in English only. Explanation. According to the California Department of Industrial Relations, employers must post notices in a conspicuous location and in languages spoken by a significant portion of the workforce. English-only postings A. may violate Labor Code SS and could be considered discriminatory. Posting notices electronically B is only compliant in addition to physical postings, including wage orders in handbook. C does not substitute for physical posting. Location accessibility must be daily or during every shift. D not weekly. Question 9. While examining employee data management, which of the following practices most likely violates California's stringent data privacy standards? A. Monitoring employee emails on company devices for security reasons. B. Sharing payroll records with an external vendor using encrypted channels. C. Accessing an employee's social media account using password credentials they voluntarily provided. D. Retaining terminated employee files for 4 years in locked cabinet. Answer. Correct answer. C. Accessing an employee's social media account using password credentials they voluntarily provided. Explanation. Under California Labor Code SS, it is illegal for an employer to request or use an employee's social media login credentials, even if voluntarily provided. This is clear violation of employee privacy rights. Monitoring email on company devices is generally permissible if disclosed. Data sharing with encrypt. B. Complies with best practices. Retention of records. D is aligned with 2 4-year retention rules under California law and is secure. Question 10. Taking into account a recent internal disclosure, Mr. Alvarez reported that supervisors were manipulating timekeeping records. Days later, he was reassigned to less favorable duties. What is the primary legal concern in this situation? A. Mr. Alvarez's performance may have prompted the reassignment. B. The reassignment may constitute unlawful retaliation under Labor Code SS.5. C. HR can delay action until the complaint is verified. D. Whistleblower laws do not apply to timekeeping manipulation claims. Answer. Correct answer. B. The reassignment may constitute unlawful retaliation under Labor Code SS.5. Explanation. California's Labor Code SS.5 is one of the strongest whistleblower protection laws in the country. It prohibits retaliation against employees who report violations of state or federal law. Change in duties after protected disclosure is considered potential adverse employment action. Employer intent is assessed, but alone can be sufficient for liability. Option A requires investigation but doesn't nullify risk. Option C violates prompt response obligations. Timekeeping manipulation. D qualifies as wage and hour violation, triggering protection. Question 11. When evaluating the merits of California's reporting time pay requirements, how should an employer respond if an employee named Mateo is scheduled for an 8-hour shift but is sent home after only working 90 minutes due to slow business day? A. Pay Mateo only for the 90 minutes he worked. B. Pay Mateo for the full 8-hour shift as scheduled. C. Pay Mateo for half the scheduled shift but not less than 2 hours. D. Offer to make up the time later in the week as an alternative. Answer. Correct answer. C. Pay Mateo for half the scheduled shift but not less than 2 hours. Explanation. Under California wage orders, Section 5, employees who report to work but are not put to work must be paid for half of their scheduled shift but not less than 2 hours and no more than 4 hours, regardless of actual hours worked. Option A fails to meet minimum pay. Option B exceeds the legal requirement. Option D doesn't excuse the employer from paying reporting time wages. Make-up time only applies when initiated by the employer and under specific circumstances per Labor Code SS. Question 12. To better understand leave policies in California, consider an employee, Anita, requesting time off to attend her child's parent-teacher conference. What is the employer's legal obligation in this situation? A. Deny the leave request if it disrupts business operations. B. Provide unpaid leave only if no accrued time off is available. C. Grant up to 40 hours per year of leave for school activities using accrued leave. D. Offer paid leave only during school emergencies. Answer. Correct answer. C. Grant up to 40 hours per year of leave for school activities using accrued leave. Explanation. Under California Labor Code SS.8, employers with 25 or more employees must allow employees to take up to 40 hours per year, 8 hours a month max, to attend school activities. This leave may be unpaid, but the employee can use existing vacation, TOE, or unpaid leave. Option A is incorrect since operational inconvenience does not excuse denial. Option B misstates the structure. Option D. Wrongly restricts the scope to emergencies. Question 13. From the perspective of compliance, Ista Patel, an HR coordinator, uses a job application form that includes a checkbox asking about criminal convictions. A candidate files a complaint after being rejected. What legal mistake may have occurred? A. Including a credit check clause in the job application. B. Failing to offer a conditional job offer before considering convictions. C. Not including a wage range on the application. D. Asking about salary history. Answer. Correct answer. B. Failing to offer a conditional job offer before considering convictions. Explanation. California's Fair Chance Act, Gov. Code SS prohibits employers from asking about criminal history before conditional job offer is made. Ista Patel's use of checkbox before an offer likely violates this law. Option A is regulated separately under the ICRA. Option C is not mandatory on applications. Option D relates to wage history bans, Labor Code SS.3, but isn't the key issue in this scenario. Question 14. Based on the information provided, what should an HR professional ensure during the onboarding process for a new California employee named Jennifer? A. Only issue a W-4 and I-9 form. B. Provide an employee handbook and optional company notices. C. Deliver all required state-specific notices, including paid sick leave and sexual harassment pamphlets. D. Wait until the employee's 30th day to issue compliance documents. Answer. Correct answer. C. Deliver all required state-specific notices, including paid sick leave and sexual harassment pamphlets. Explanation. California law requires employers to provide several mandatory notices at onboarding, such as paid sick leave notice, Labor Code SS.5, sexual harassment pamphlet, and state disability insurance (SDI) brochure. Failing to do so can lead to non-compliance. Option A covers only federal tax documents. Handbooks B are recommended but not substitute for legal notices. Option D delays critical disclosure obligations. Question 15. Across different scenarios, which of the following employer practices would violate California's requirements for lactation accommodation? A. Providing clean, private break room near the employee's work area. B. Offering locked office space during breaks for lactation. C. Allowing use of restroom stall for expressing milk. D. Granting unpaid additional breaks for pumping sessions. Answer. Correct answer. C. Allowing use of a restroom stall for expressing milk. Explanation. California Labor Code SS mandates that employers cannot require lactating employees to express milk in restroom. The space must be private, secure, and not bathroom with access to electricity and seating. Options A, B, and D all meet acceptable accommodation standards, though breaks must follow wage and hour rules. Violations may result in civil penalties under Labor Code SS. Question 16. During the process of interactive dialogue, an employee named Carl, recently diagnosed with severe arthritis, requests to work remotely 3 days a week. What is the employer's primary obligation under California law? A. Automatically approve the request without assessing business needs. B. Refuse the request unless supported by doctor's letter. C. Engage in good faith interactive process to determine if remote work is reasonable accommodation. D. Deny the request due to company remote work policy. Answer. Correct answer. C. Engage in a good faith interactive process to determine if remote work is a reasonable accommodation. Explanation. Per California Government Code SSN and DFA guidance, employers must engage in an individualized assessment and dialogue with the employee to determine feasible accommodations, including remote work. Denial without discussion. D. Automatic approval. A. Skips due diligence. Medical documentation may be needed eventually, but is not the first required step. Question 17. The most significant aspect of California's approach to equal pay and discrimination is demonstrated in which of the following practices? A. Allowing salary negotiations to determine final pay. B. Requiring justification for pay differences based on seniority or merit. C. Paying different rates to employees in the same role based on education level alone. D. Using geographic location to determine pay for remote workers. Answer. Correct answer, B. Requiring justification for pay differences based on seniority or merit. Explanation: California's Equal Pay Act, Labor Code SS.5 mandates equal pay for substantially similar work and requires that any disparities be justified by bona fide factor such as seniority, merit, education, if job-related, or production. Option B reflects lawful justification. Option A risks perpetuating bias. Education C is insufficient alone. Geographic pay D is acceptable only if consistently applied and not used to mask discrimination. Question 18. Examining the consequences of abrupt terminations, Rosa was let go one day after returning from PHRca leave. She believes the termination was retaliatory. How should the employer defend against liability? A. Show Rosa's position was eliminated before her leave ended. B. Explain that her replacement was more qualified. C. Claim no intent to retaliate existed. D. Offer her another position post-termination. Answer. Correct answer. A. Show Rosa's position was eliminated before her leave ended. Explanation. Under PHRca Gov. Code SS.2, employees returning from protected leave are entitled to reinstatement. Termination shortly after return may suggest retaliation unless the employer can prove legitimate, non-retaliatory reasons such as layoff decision made prior to the leave's end. Intent C and qualifications B are insufficient defenses. Offering another role after termination D does not cure liability. Question 19. With the advent of evolving privacy laws, which of the following practices could expose an HR department to legal risk under California's CPRA? A. Sharing anonymized workforce data with benchmarking firm. B. Requiring employee consent before monitoring digital communications. C. Retaining sensitive data beyond the necessary retention period. D. Encrypting personnel files stored in the cloud. Answer. Correct answer. C. Retaining sensitive data beyond the necessary retention period. Explanation. Under the California Privacy Rights Act, CPRA employers must limit data retention to what is necessary and proportionate. Holding personal data longer than required violates data minimization principles. Option A is compliant if anonymized. Consent B enhances protection. Encryption D is a best practice. Unjustified retention C may result in regulatory penalties and civil actions. Question 20. In an effort to minimize legal exposure, which of the following strategies would most effectively reduce the risk of Private Attorneys General Act PHRca claims? A. Avoid implementing arbitration agreements with class action waivers. B. Regularly audit wage and hour compliance and correct issues proactively. C. Limit employee access to their personnel files. D. Offer release waivers at the end of every pay period. Answer. Correct answer. B. Regularly audit wage and hour compliance and correct issues proactively. Explanation. PHRca Labor Code SS 698 2699.6 allows employees to bring actions on behalf of the state for labor code violations. The best mitigation strategy is proactive, conduct internal audits, fix violations, and maintain records. Arbitration A. Doesn't block PHRca. Limiting file access C. May increase non-compliance risk. Frequent waivers D. Are not enforceable without consideration and may be deemed coercive. Question 21. The underlying principle of worker classification is at issue when an HR manager, Caleb, hires a graphic designer to work remotely, sets specific work hours, and supervises the work using daily reports. Which of the following best identifies the legal concern under California ABC test? A. The designer is properly classified as an independent contractor paid by project. B. The worker is misclassified due to lack of control over their work product. C. The worker likely fails Part B of the ABC test and should be classified as an employee. D. The worker qualifies as exempt if they earn more than twice minimum wage. Answer. Correct answer. C. The worker likely fails Part B of the ABC test and should be classified as an employee. Explanation. California ABC test above B5 presumes a worker is an employee unless A. Free from control, B. Performs work outside the usual course of business, and C. Is independently established. Since the designer's services resemble the company's business and are supervised, Part B fails, triggering employee classification. Project Pay A doesn't override the ABC test. Exemptions D apply only to employee status, not to contractor classification. Lack of control B actually supports independent status. Question 22. To determine whether California recognizes true employment at will, which situation best illustrates a limitation to this doctrine? A. Terminating an employee for tardiness after progressive discipline. B. Ending employment during probation without cause. C. Dismissing a worker for refusing to perform illegal activities. D. Firing an employee after downsizing is announced. Answer. Correct answer. C. Dismissing a worker for refusing to perform illegal activities. Explanation. While California is an at-will employment state, Labor Code SS exceptions include public policy violations. Terminating an employee for refusing to engage in illegal acts is unlawful under Tammany v. Atlantic Richfield Company, 1980. Options A, B, and D fall within the at-will doctrine unless other laws, e.g. discrimination, are involved. Courts uphold wrongful termination claims when fundamental public policy is breached, as in C. Question 23. Taking into account California wage and hour regulations, what is a critical compliance error when implementing electronic timekeeping systems? A. Rounding hours up or down to the nearest 15-minute mark. B. Failing to display break and meal periods separately. C. Allowing employees to input their own hours daily. D. Not having a backup method during system outages. Answer. Correct answer. B. Failing to display break and meal periods separately. Explanation. California requires detailed records for meal and rest breaks under Labor Code SS and wage orders. Omitting these on time cards or wage statements creates exposure under Labor Code SS.7. Rounding A is permitted if neutral and doesn't shortchange employees. Employee self-entry. C is fine if accurate. Backup methods. D are good practice, not mandated. Question 24. The question remains whether an employee who quits voluntarily is eligible for CalCobra continuation coverage. Which of the following is true? A. Employees who quit are not eligible for CalCobra. B. Employees who resign are eligible if previously covered under a group plan. C. COBRA applies only if the employee is terminated involuntarily. D. CalCobra requires proof of financial hardship to qualify. Answer. Correct answer. B. Employees who resign are eligible if previously covered under a group plan. Explanation. CalCobra Health and Safety Code SS.20 etc. provides continuation of group coverage for qualifying events, including voluntary resignation, provided the employee was covered at the time. Option A misinterprets eligibility. Federal COBRA C also allows continuation after voluntary separations. Hardship D is not condition. The only disqualifiers are gross misconduct or ineligibility due to coverage lapse. Question 25. The validity of posting practices is questioned when a company relocates to a temporary office space and fails to redisplay compliance posters. Which of the following is a legal risk? A. Posters are not required during transitions. B. Posting on the company website during the move is sufficient. C. Failure to post may result in state penalties and employee claims. D. Posters are optional for offices with fewer than 10 employees. Answer. Correct answer. C. Failure to post may result in state penalties and employee claims. Explanation. California law. G. Labor Code SESC poster requirements mandates that posters be physically displayed in conspicuous locations. Failing to post even during move can result in civil penalties and claims for willful violations. Online posting. B. Does not replace physical display. No exemptions exist for office size. The employers must update postings immediately upon relocation. Question 26. During the process of revising emergency protocols, Jordan, an HR manager at a warehouse in Bakersfield, learns that the building lacks a written evacuation plan. What legal and safety issue must Jordan prioritize? A. Post the OSHA workplace rights poster. B. Conduct a fire drill within 90 days. C. Develop a written emergency action plan compliant with OSHA. D. Send safety tips via company email. Answer. Correct answer. C. Develop a written emergency action plan compliant with OSHA. Explanation. Under Title 8 HRCI, employers must create written emergency action plan (EPA) when required by CALOSHA. This includes evacuation procedures, fire safety, and employee training. Option A is separate fire drills. B are encouraged but not substitute. Emailing tips. D doesn't meet regulatory requirements. Jordan must ensure written protocols exist for safety, compliance, and legal protection. Question 27. As a result of recent legislation, what is a California employer with 7 employees required to do regarding sexual harassment training? A. Provide 1 hour of training to all employees within 6 months of hire. B. Offer training only to supervisors once every 2 years. C. Deliver 2 hours of training to supervisors and 1 hour to non-supervisors. D. Provide training only if a complaint is received. Answer. Correct answer. C. Deliver 2 hours of training to supervisors and 1 hour to non-supervisors. Explanation. SB 1343 amended Gov. Code SS.1, requiring employers with 5 or more employees to provide 2 hours of harassment training to supervisors and 1 hour to all other employees every 2 years and within 6 months of high promotion. Option A partially describes the rule. Option B omits non-supervisory obligations. Option D ignores the proactive training requirement. Question 20. From a historical standpoint, which paid sick leave accrual method is compliant under California's Healthy Workplaces, Healthy Families Act? A. Accrual of 0.5 hours per 40 hours worked with 10-day usage cap. B. Immediate front-loading of 24 hours per year. C. Accrual of 2 hours per week without carryover. D. Providing paid sick leave only after 90 days of employment. Answer. Correct answer. B. Immediate front-loading of 24 hours per year. Explanation. California allows employers to accrue or front-load paid sick leave. Labor Code SS permits front-loading 24 hours or 3 days at the beginning of each year, avoiding accrual carryover issues. Options A and C deviate from standard accruals. Option D is misleading. Accrual begins immediately, though usage may be delayed for 90 days. Question 29. To illustrate this point, what is the primary reason for regularly updating California employee handbooks? A. To reflect evolving trends in employee satisfaction. B. To maintain alignment with federal labor laws. C. To ensure compliance with frequent state and municipal legal updates. D. To improve the company's marketing and branding. Answer. Correct answer. C. To ensure compliance with frequent state and municipal legal updates. Explanation. California employment laws change frequently at both the state and local level. Handbooks must reflect these changes, e.g. paid leave, harassment training, local ordinances to reduce litigation risk and demonstrate compliance. Federal laws be applied, but California-specific updates dominate employee satisfaction. A. Branding. D. Are non-legal drivers. Question 30. What would happen if an employer fails to honor an employee's predesignated personal physician in a workers' compensation claim under California law? A. The claim is automatically denied by the state. B. The employee must see physician chosen by the employer. C. The employer may lose medical control and face penalties. D. The employee's coverage is converted to private insurance. Answer. Correct answer. C. The employer may lose medical control and face penalties. Explanation. Under Labor Code SSD, an employee may predesignate personal physician before an injury occurs. If the employer fails to honor the designation, they may lose medical control, face penalties, and increase claim exposure. Option A is incorrect. Claims aren't denied on this basis. Forcing company doctor. B. May be unlawful. Coverage. D. Remains workers' comp, not private insurance.